in session. Please be seated.
Senior Judge Morgan could only take so much. So he called Memphis and got Judge Armstrong back. Anyway, Judge Armstrong, Judge Kenny Armstrong from Memphis joining the panel. Anything we need to take up, Miss Angie?
No, Your Honor.
You may call the next case, please.
Angel Marie White et al. Versus Jennifer C. Goodfred D.O. et al.
May it please the court, I'm Duncan Ragsdale from the Memphis Bar. I represent the appellant. Could I reserve 5 minutes for rebuttal?
Yes, sir, you may.
In a motion to dismiss for failure to state a claim under Rule 12.026, what happens when the judge considers matters outside the pleading? Well, it converts the motion to a Rule 56 motion for summary judgment, and the finding has to be whether or not there are disputed issues of fact.
Mr. Ragsdale, that's true. I think we can all agree on that, but the judge in this case, in her order, specifically said that she was not considering matters outside the pleadings.
But she did.
Well, she says she did not, and she specifically gets pretty specific about what she didn't consider, I think.
Got it.
And says,
Well, I presented matters outside the pleading.
following argument by counsel, the court determined it would consider only the allegations in the complaint and amended complaint and decide UTMG's motion under a motion to dismiss standard. Because the plaintiff seeks to rely on the doctrine of fraudulent to toll the statute of repose, the court must also consider the elements required to establish fraudulent concealment and the pleading standard required for alleging it, and basically said there was not pled.
Well, her finding is plaintiff cannot prove any set of facts that would establish fraudulent concealment. The question is that a finding of fact? And so if it's a finding of fact, then...
No, she's saying that it was not properly pled in the complaint. There was no facts to support that in the complaint. This is a motion to dismiss.
Right. The complaint alleges that the defendants falsified, concealed, or destroyed records in an attempt to avoid liability in the case at issue. The significance of that is that the notes, the office notes on July 27, 2012 state procedure, implant-on insertion after the patient, when counseled and consent form reviewed and signed, a universal protocol was performed. The complaint alleges that that's false, that never happened, and that if that never happened, then there's a fraudulent concealment. The record shows that there were no consent forms that have been produced. That's alleged, I believe that's alleged in the complaint. Under the facts section.
Let me, as I read the issues that were presented, there's not an issue that either state says that the court considered matters that were outside the pleadings or did not consider matters that were outside the pleadings as an issue on appeal.
Well, I suppose if the court makes that announcement, then we're bound by that. However, we argued that to the court at the time.
You can't argue it if it wasn't raised as an issue.
Well, you're right about that. I agree with that. Under the...
Well, let me ask you about your fraudulent concealment. You said they didn't keep notes, and so they don't have the documentation about having the consent of the parent for the depot or for the insert.
Right.
But the parties would have been aware of both of those. Is that right?
No. Angel White has taken the position, I believe it's in her complaint as well, that they never told her about the adverse effects of implant-on or Depo-Provera. The documents show that they said she signed a consent form, and the consent form was supposed to be placed in the record. There's no consent form ever been produced. That's one of the facts that we have alleged down there in the court. Relative to falsification of records, count 2 of the complaint says the defendant intentionally falsified, destroyed, or concealed records containing material evidence with the purpose of wrongfully evading liability in the case at issue, and as a result, plaintiff was damaged. How is that not fraudulent concealment? The court has to decide that, I would think. I suggest that's fraudulent concealment. If a group of doctors has a duty to obtain informed consent, which we all agree that they do, but they intentionally falsify those records, destroy or conceal those records containing material evidence with the purpose of wrongfully evading liability in the case at issue, is that not fraud? If that's true, then the complaint alleges a claim for relief for fraudulent concealment of a cause of action. And that's on page 14 of my brief. And I back it up by other paragraphs in the complaint. 12, for example, UT Medical Group, Inc. failed to obtain informed consent for the Depo-Provera injection on 2/28/2018, and thereafter Desiree Jameson was a minor and not competent to give informed consent, and the defendants failed to obtain informed consent from Angel White, her mother. 13, UT Medical Group provided plaintiff a copy of Desiree Jameson's record on or about 12/21/2018, but failed to include any informed consent documents concerning the Depo-Provera. That's in the complaint. Desiree Jameson took the Depo-Provera injection every 3 months until March the 9th, 2012, when she was 15 years old. 15. On March the 9th, 2012, UT Medical Group employees noted a weight gain of 40 pounds in 1 year and sent a BMI of 46 kilograms per meter squared. But again, failed to obtain informed consent to continue injections. There's no informed consent from the record showing Angel White gave her consent for Desiree Jameson's Depo-Provera injections.
So it's your position that no informed consent forms were presented?
That's correct. They've admitted that. And our complaint alleges, they didn't provide those forms to us. And they didn't. They still haven't. And so I've been reading the paragraphs from the complaint that the judge says didn't show a fact situation that would amount to fraudulent concealment. I disagree.
I think what you said is that the failure to inform that the fact that the plaintiff has failed to allege facts in the complaint, the amended complaint, that if true, the cause of the opinion as it relates to a treatment provided, the facts alleged in the complaint and amended complaint at most state a claim for lack of informed consent. Lack of informed consent does not equate to fraudulent concealment under the factors that Tennessee appellate courts have outlined to establish fraudulent concealment.
Well, I don't think that's correct. As far as what the complaint said, paragraph 14 of my argument, means page 14 of my argument, it includes paragraph 34 and paragraph 10 through 18. That alleges the facts about them failing to provide those forms. While plaintiff requested all Desiree Jameson's records, and UT Medical Group failed to provide the Implanon TM patient consent form. We know that the manufacturer requires that consent form be maintained in the file and a copy given to the person, the patient.
What case do you have to support the fact that lack of informed consent equals fraudulent concealment?
The statute, the 2939-102 regarding damages, it says if the defendant intentionally falsified, destroyed, or concealed records containing material evidence with the purpose of wrongfully evading liability in the case at issue.
That's not what we're talking about.
I understand.
The question is, you're saying that lack of informed consent equals fraudulent concealment. I'm asking you.
No.
Do you have
I'm
a
saying
Tennessee case that supports that?
No, I'm not saying that.
I mean, you may have had a cause of action for not providing informed consent, but you have a statute of limitations on that. You have a statute of repose on that. Is there anything that says if you don't do that, that creates a fraudulent concealment?
This is probably a case of first impressions. I don't have any authority for
So
this.
there's nothing. So why is the court wrong? Why are you saying?
Well,
the
wait.
court's wrong
Let
here?
me explain. if the doctor or the institution intentionally falsifies, conceals, or destroys records, that's fraud.
You're saying there's no record, didn't provide for
They
informed
can,
consent.
they claim an exhibit on
There wouldn't be a
July.
record, there wouldn't be a record if the court, if the doctor failed to provide informed consent.
There's no informed consent form that they produced. We allege that in the complaint. The procedure, quoting the procedure, implant-on insertion after the patient was counseled and consent form reviewed and signed, a universal protocol was performed. That's false based on the affidavit of Angel White. And my argument to the court is that if the doctors or the hospital says they had them sign a consent form and that's false, then that's a fraudulent concealment. Why is it fraudulent concealment? Because the consent form tells you all the adverse effects.
I thought you said your client said that they never provided informed consent.
That's right.
What do
They
you-
never informed her of,
And I'm just saying, how does that equate to fraudulent concealment? And is there any case that supports that?
I don't have a case that supports that. This is a case of first impressions. It's my argument to the court that if a doctor intentionally falsifies, destroys, or conceals records with the purpose of avoiding liability in the case at issue, and that prevents the patient from understanding or learning about the negative effects of the treatment, then that is informed consent, a fraudulent concealment case.
Let me ask you, Mr. Ragsdale, in a healthcare liability case, if it's based on a lack of informed consent, when does the statute begin to run on that claim?
I would think it'd begin to run when the patient understands that there's no informed consent. Now, Shadrick versus Coker discusses this. It says when the healthcare provider performs the treatment or procedure without the requisite informed consent of the patient, liability attaches for the resulting injuries regardless of whether those injuries resulted from negligence. That's the closest I can come to.
Well, that doesn't really address my issue.
Right, it really
When
doesn't.
does the statute begin to run?
I would say the statute begins to run when a patient, if there's fraudulent concealment, the statute
No,
begins to
when there's
run.
no informed consent. Let's
Well, that
assume
would-
There's no informed consent. When does the statute begin to
Well-
claim when a patient sustains an injury that the patient may have discovered if they had been properly informed?
I think the 3-year cap requires you to find that out in the 3 years unless there's fraudulent concealment. And then when there's fraudulent concealment, it's a year from the date you discover the fraudulent concealment.
Okay.
All right, thank you, sir. You
Thank you.
used your original time. We'll hear from the appellate. Are you making the only argument?
I'm not, Your Honor. I'm going to take 13 minutes of the time and allocate 2 minutes to Ms. Colturi, who represents the state of Tennessee.
Okay.
I will say that the arguments are essentially the same, but I'll be referencing UTMG in particular.
All right, you may proceed.
May it please the court. My name is Samantha Bennett, and I'm a member of the Memphis Bar, and I represent UT Medical Group in this appeal. This appeal arises from the trial court's dismissal of claims against UT Medical Group, which I'll refer to as UTMG, related to care that was provided to the decedent by UTMG providers in 2011 and 2012 on grounds that the claims were barred by the 3-year statute of repose and that the statute of repose was not told by the doctrine of fraudulent concealment. The complaint and amended complaint in this case alleged that negligence of UTMG providers in 2011 and 2012, and then again in 2017, resulted in Ms. Jemison's death in June of 2018. The complaint was then filed in October of 2019, which would have been more than 4 years after the statute of repose expired. There's no dispute in this case that unless there is an applicable tolling doctrine, the claims arising from the 2011-2012 treatment are barred by the statute of repose. In opposition to our motion to dismiss, the plaintiff argued that the statute of repose was told by the doctrine of fraudulent concealment. The plaintiff bears the burden of both pleading and proving fraudulent concealment. UTMG argued to the trial court, and the trial court agreed, as Judge Golden noted in the judge's order, that the plaintiff failed to adequately plead fraudulent concealment as an exception to the statute of repose, entitling UTMG to dismissal of those claims. Today, the UTMG asked this court to find that the statute of repose was not told by the doctrine of fraudulent concealment and affirm the trial court's dismissal. I do think before going into the substantive issues, it is significant to point out the judge ruled on this motion as a motion to dismiss. The plaintiff attempted to bring matters outside of the pleadings before the court, did argue those. Simply bringing matters outside the pleadings before the court does not trigger the conversion of a motion to dismiss to a motion for summary judgment. The judge has the discretion whether or not to consider those materials. In fact, during an oral argument in the trial court, I asked the court on at least 2 occasions whether she wanted me to address plaintiff's arguments related to matters outside the pleading, and she told me no. It's clear from the court's order that she only considered what was alleged in the complaint, in the amended complaint. As a result, in the plaintiff's brief, there are the majority of the plaintiff's brief addresses matters that are outside the pleading, argues this in terms of a motion for summary judgment, and that is an inappropriate standard. The court did not consider matters outside the pleading, and neither should this court on appeal. I would also just like to briefly mention that in the plaintiff's course of arguing matters outside the pleading and addressing the appeal as though it were a motion for summary judgment, the plaintiff never really addresses the dispositive issue on appeal, which we believe also constitutes a waiver of this issue. The plaintiff never addresses whether or not a fraudulent concealment was actually adequately pled in the allegations of the complaint. The issue before this court is whether the trial court properly granted UTMG's motion to dismiss when it held that the plaintiff failed to adequately plead fraudulent concealment to toll the statute of repose. The answer to this question is yes. The essence of a claim of fraudulent concealment is that the defendant concealed from the plaintiff facts material to the cause of action that prevented the plaintiff from being able to timely bring the action. There are 4 elements that must be pled and proven to establish fraudulent concealment. We address those in our brief, but just briefly, the defendant must have affirmatively concealed the plaintiff's injury or the identity of the wrongdoer. The plaintiff could not have discovered the injury or identity of the wrongdoer despite exercising reasonable care and diligence. The defendant knew that the plaintiff had been injured and the identity of the wrongdoer, and the defendant concealed material information in order to exclude suspicion or prevent inquiry. Accepting the factual allegations in the complaint and amended complaint as true, as required on a motion to dismiss, the plaintiff has failed to adequately plead fraudulent concealment. In the trial court, the plaintiff essentially made 2 arguments, one that only came up in response to the defendant's motion to dismiss. The first is that UTMG fraudulently concealed medical records. The second, the plaintiff argued that UTMG providers concealed from the plaintiff the potential risks associated with the contraceptives that were prescribed to the decedent. It is against the backdrop of these 2 arguments that we have to analyze the allegations in the complaint and amended complaint. At the outset, we have to take into consideration that fraudulent concealment involves an allegation of fraud implicating Rule 9.02 and requires that the circumstances constituting the fraud be stated with particularity. In order to meet the particularity test, a plaintiff must allege specific facts that, if true, establish an intentional misrepresentation of a material fact. General allegations and conclusory allegations of fraud are not sufficient. We turn now to the complaint and amended complaint, first on the issue of concealment of records. At page 8 of the complaint, as Mr. Ragsdale quoted, the plaintiff states the defendants intentionally falsified, destroyed, or concealed records containing material evidence with the purpose of wrongfully evading liability in this case, and as a result, the plaintiff has been damaged. This statement contains 0 facts. It is a conclusory allegation that this court is not required to accept as true. The law is that conclusory allegations are insufficient to plead fraud. The only factual allegation in the complaint that could conceivably be related to the plaintiff's claim that UTMG fraudulently concealed records is the allegation that we see in paragraphs 13, 15, 16, and 17, that the medical records were requested by the plaintiff in December of 2018 and did not include the consent forms for the contraceptives. These statements, simply that consent forms were not in the records, is not a particularized statement constituting fraud. It simply doesn't meet that particularized standard. The fact that the contraceptives consent forms were not in the record, if that allegation is true, does not establish an intentional concealment of records. Not only did the plaintiff fail to plead fraud with particularity as required by Rule 9.02, but the plaintiff didn't plead the other elements of fraudulent concealment that must be pled in order to sustain a claim for fraudulent concealment. There's no allegation that the providers knew that the decedent had sustained an injury or that there was information in the consent forms that was material. In our brief, we argued a number of other bases that would support dismissal of the claim of fraudulent concealment based on the concealment of records. And I'll rely on our briefing for most of those, but there is one that I think is very significant, and that is that fraudulent concealment requires an act of concealment within the repose period, when, but for the concealment, the plaintiff would have been able to bring a timely cause of action. The complaint in this case alleges that the plaintiff requested records from UTMG in December of 2018. That is more than 3.5 years after the statute of repose had already expired. The fraudulent concealment, the doctrine of fraudulent concealment simply cannot revive a cause of action that was extinguished by the statute of repose years prior to the alleged concealment. We also advanced a number of other arguments, and I'll rely on our briefing for those. But if we turn now to the complaint and amended complaint in relation to the plaintiff's argument that the UTMG providers in 2011 and 2012 fraudulently concealed from the plaintiff the potential risks associated with the contraceptives prescribed to the decedent. Here, as the court has noted, the plaintiff is basically arguing that a lack of informed consent is fraudulent concealment. And that is simply not correct. Informed consent implicates a physician's duty to provide a patient with enough information about a proposed course of treatment before providing the treatment to allow the patient to make an intelligent decision about whether or not to proceed. In this case, with respect to fraudulent concealment in this context, the plaintiff is basically arguing that there was a failure to disclose information, lack of informed consent, and in this case, the failure to disclose relates to the defendant's failure to disclose material facts regarding the patient's injury or the identity of the wrongdoer after treatment has been provided. There are certain circumstances under which you might be able to piggyback a claim of fraudulent concealment on a claim of lack of informed consent, but this is not that case. A plaintiff who relies on a claim of lack of informed consent as a basis to claim fraudulent concealment must still allege and prove fraudulent concealment above and beyond alleging and pleading the lack of informed consent claim. Like the allegation of concealment of records, the plaintiff has failed to plead any circumstances constituting fraud in this context. There's no facts that the plaintiff can point you to that, if true, establish that there was action constituting fraud. The plaintiff, again, has also failed to allege facts that, if true, would support the remaining elements of the fraudulent concealment claim, including knowledge by the providers that there was an injury and the identity of the wrongdoer. Moreover, and I think this is an important point as well, it's our position that the plaintiff has not even adequately pled a claim of lack of informed consent that the plaintiff could argue constitutes fraudulent concealment. In this case, the plaintiff's claim of lack of informed consent is based on a failure to obtain informed consent from the decedent's mother for the contraceptives that were prescribed because the patient was a minor and not able to consent. That is not the law in Tennessee. TCA 68-3-107, an interpreting case law, says that a minor can request and receive contraceptives without parental consent. It was the informed consent of the minor, the decedent, that was required in this case. And the complaint does not allege a lack of informed consent by the minor. So the plaintiff has not even pled adequately a claim for lack of informed consent. That could even get you then to whether or not that claim could be the basis for an allegation of fraudulent concealment, which we believe it was not pled either. And again, in our brief, we address a number of other bases to support dismissal with respect to the allegations related to lack of informed consent. And we'll rely on our briefing for those, except for there's one I want to mention, and that is that fraudulent concealment requires concealment by the defendant of facts material to the discovery of the plaintiff's cause of action. Specifically, that the defendant concealed the plaintiff's injury or the identity of the wrongdoer. However, the plaintiff's allegation in this case is a failure to advise of potential risks of contraceptives before prescribing them. This allegation doesn't relate to an injury or the identity of a wrongdoer, and therefore the plaintiff has not alleged fraudulent concealment as required in order to, has not established that these facts are material in order to plead a claim of fraudulent concealment. And for these reasons, we ask that the court affirm the trial court's dismissal of the claims against UTMG for treatment arising from the 2011-2012 treatment, finding that they are barred by the statute of repose and that the statute of repose was not told by the doctrine of fraudulent concealment. As I see that I'm almost out of time, but I'm happy to address any questions the court may have.
I see none. Thank you.
Thank you.
Good afternoon. I am Heather Colturi from the Memphis Bar, and I represent the state of Tennessee in this matter. The state of Tennessee filed a joinder in the trial court in UTMG's motion to dismiss the 2011 through 2012 OB claims. And the trial court granted the state of Tennessee's joinder for the same reasons that it granted UTMG's motion. Therefore, to the extent that the state incorporates all the arguments raised by UTMG on appeal and argued here today, the only additional issues that I am raising here is that the state of Tennessee's joinder in UTMG's motion to dismiss was really an alternative argument in which the state said the complaint doesn't sufficiently plead subject matter jurisdiction, i.e. the alleged negligence of a state employee, and therefore there's no claims, the court should dismiss the claims, the 2011 through 2012 claims against the state of Tennessee for lack of subject matter jurisdiction. But if the court finds that there is subject matter jurisdiction, plaintiff has adequately pled subject matter jurisdiction, then the state joins in that motion. The court didn't address lack of subject matter jurisdiction in her ruling, but plaintiff's appellate brief and argument here today indicate that actually plaintiff does not address the state of Tennessee complaint or allegations against the state or identify pleadings or other facts demonstrating that state of Tennessee employees, that would be UT resident physicians, were involved in the patient's care in 2011 through 2012.
Isn't the court required to deal with subject matter jurisdiction first?
Yes, it's a threshold issue that the court, even though the trial court didn't expressly rule, this court can and should consider it any time, because without subject matter jurisdiction, the trial court had no authority to rule on the underlying issues. So if there is no subject matter jurisdiction, that deals with the issue against the state right away. So that's really the additional issue, is plaintiff didn't address any issues on appeal, hasn't pled subject matter jurisdiction against state.
Don't leave yet.
Yeah, I'm sorry.
I want to ask you about the second issue that the state raises. It says whether this court should dismiss plaintiff's appeal against the state because plaintiff has waived appellate review based on her failure to comply with the rules of appellate procedure.
So this appellant's brief does not, there are the additional issues, plaintiff's brief does not adequately comply with the rules regarding the statement of the statement of the case. So it doesn't discuss the procedural history, but specifically as to the state, it doesn't actually discuss anything related to the procedural history relating to the state's joinder, the state complaint. Plaintiff didn't even include in the appellate record the complaint against the state. The statement of the facts does not include any facts material to the resolution of the issues against the state. as required by the Tennessee Rules of Appellate Procedure 27A. As well, plaintiff didn't include any argument regarding the trial court's ruling granting the state's motion to dismiss the 2011 through 2012 claims. She utterly waived the issue by not addressing the trial court's ruling against the state.
I'd like to address one issue that Ms. Bennett brought up, and that is an injury within the statutory period. On page 15 of the brief, paragraph 15 of the complaint states that on March the 9th, 2012, UT Medical Group, Inc. employees noted a weight gain of 40 pounds in 1 year, but again failed to obtain informed consent to continue the injections. It's our contention that the 40-pound weight gain in 1 year is an injury that we've alleged in the complaint within the period required. They didn't tell her what caused this. They didn't say anything about it. They just noted it in the record. And so, matter of fact, what they did say was, well, your weight gain is due to eating fast food and getting no exercise. And we say that's not correct. But as far as whether there's an injury within the statutory period, it occurred, it was identified on March the 9th, 2012, with the note of a weight gain of 40 pounds.
I'm sorry, how does identifying 2012 as a date of injury help you with the issue of the statute of limitations and the statute of repose?
Well, Ms. Bennett made the point that there wasn't any allegation of an injury within the statutory period. I'm simply bringing it to the court's attention that there was evidence of an injury with a 40-pound weight gain in 1 year.
Okay.
Thank you, sir.
Thank you, Your Honor.
Thank you, counsel. We will take this matter under advisement, review the record, and attempt to get you an opinion at the earliest possible time. You may be excused.